We will be sharing a recording of this program with everyone who has registered so that we can share it widely with your networks. And now I'm going to turn it over to Alan.
Okay, well, to get started, our first guest today is attorney Nathan Lewin, a very distinguished litigator of church-state cases, too numerous to list, and for a very long time at that, having graduated Harvard Law School in 1960 when I was quite literally emerging from diapers. But today it is not your Supreme Court appearances, but a legislative success that is the subject of our webinar. Because Nat, I understand that you had a particular role in the drafting and enactment of the 1972 amendments to Title VII that we know of as the religious accommodation provisions. So maybe you can start and tell us a story of how that came about.
Well, I'm very happy to be here and honored to join this very respectable and respected group on this very important subject, which continues to be of interest to this very day and in the current Supreme Court docket. I am a graduate of Yeshiva College, Orthodox Jewish, Sabbath observer, and quite frankly, during the time that I graduated, was in law school and graduated law school, that was a period when New York City law firms, for example, were very openly anti-Semitic and said they would not hire any Jewish lawyers. Even the firms that were Jewish or partially Jewish said and told me they would not hire a Sabbath observer. I applied, quite frankly, in the class of 1960, I ranked above my classmate who ultimately made it to the Supreme Court, and that was Antonin Scalia. I ranked higher in the class than Justice Scalia. We were friends all our lives, notwithstanding that interesting occurrence. But I was, after I graduated, worked for Judge Lombard on the Second Circuit, Justice Harlan on the Supreme Court. They were very sympathetic, did not make me work from Friday afternoon, Saturdays, or Jewish holidays. I went to the Department of Justice under Archibald Cox and Thurgood Marshall. They also were very accommodating, although the Department of Justice had to stretch some regulations to accommodate my Sabbath observance. But I felt all along that to the extent I would be able as a lawyer to effect some legal change that would make it easier for Sabbath observers in the private marketplace and with the government. And there was another statute besides this one that I worked on that had to do with government employment, that I would do what I could. I went into private practice in 1969. And one of the first amicus briefs I wrote in the Supreme Court was a case called Dewey versus Reynolds Metals. That was a case in which the issue was whether the prohibition in the Civil Rights Act of 1964 against discrimination on account of religion included discrimination on account of religious observance. Mr. Dewey was a Sunday observing Christian, I believe. I think that was it. But in any event, he was discharged by the Reynolds Metals Company because he would not work one day a week. That case went all the way up to the Supreme Court with the Sixth Circuit, I believe, ruling against him on the original language of the 1964 Act. And the question was whether discrimination on account of religion included discrimination on account of religious observance. If an employee was not able to work one day a week, did an employer have to make an accommodation for it? Well, it turned out that Justice Harlan, for reasons which I don't think had to do with specifically with that case, but maybe with some ownership of stock or something, but he did not participate. The case came to the Supreme Court, And I wrote an amicus brief on behalf of the Orthodox Jewish community for an organization called National Jewish Commission on Law and Public Affairs, for which I've been writing briefs ever since 1970. And that includes virtually all the national Jewish organizations, the Orthodox Union, Agudath Israel. This is an umbrella group. I wrote a brief in which I said, surely religion should include observance. Indeed, the EEOC had in 1967 specifically amended an earlier regulation, which said, no, if you had a uniform day, a uniform week for all employees had to accommodate, and it was not, had to accept that. It was not a violation of the statute. But the EOC changed that regulation in 67, and it said that religion included religious observance, all aspects of religious observance. And we argued in that case, as did Dewey's lawyer, that the EOC regulation should control. Well, the court split 4-4. Now, again, I can go through long recitation, which I won't do in the interest of time, but that issue was the one that got me and others to say we have to amend the statute. And in 1972, I personally drafted the amendment to the statute, first proposed it to Senator Williams of New Jersey. And he said, no, there's somebody better to do that. And that's Senator Jennings Randolph of West Virginia, because he's a Saturday observing Baptist, a Seventh-day Baptist. By then, the amendments to the Civil Rights Act had essentially passed the Senate already, or passed the House, and were pending on the floor of the Senate. And Jennings Randolph proposed my language in 1972, and all the senators on the floor, out of respect for him, he was a senior member, he was in his 70s. I thought, boy, that was aged. I now think, but in any event, Senator Randolph proposed it, the Senate unanimously adopted it, and the conference committee, which of all historical accidents, met on the Jewish holiday of Purim, which is the great liberation day for Jews. The conference committee accepted that amendment, and it became law. That's how the 1972 amendment really was enacted into law. Of course, subsequent to that came another case in which the court divided 4-4, Parker Seals Company versus Cummins, in which the constitutional issue was more squarely presented after the bill, and still the court split 4-4. So there's been constant disagreement in the court, and I won't go. I suppose maybe later on in this session we'll discuss some of the cases that succeeded it, including TWA versus Hardison, in which I argued in the Supreme Court, but lost. I argued as an amicus, who's given special permission to argue. And in that case, Justice Byron White said in his opinion that an employer didn't have to make any more accommodation than a de minimis accommodation. That was a disastrous opinion, and I hope the Supreme Court will, in this coming year, overrule that. There are 3 justices who have already said they would, and I think there are more justices who would join that. But I'll leave all that for the rest of the discussion in this session.
Well, Nat, I have a couple of key questions that come from your discussion, and I have not heard this story before, so I have been eagerly awaiting and very grateful to get to hear it. The first question is, so as Scalia observed and parsed the language of the amendment in the EEOC against Abercrombie case, the provision requiring religious accommodation of religious practices was affected by means of amending the definition of religion, adding language to the definition of religion. Now, a number of states, California among them, have standalone provisions where you have a separate cause of action for failing to provide religious accommodation. Why was the amendment drafted that way, as amending the definition of religion? That's been confusing to some of us litigators for many, many years.
That's a question that you're going to have to ask whoever at the EEOC amended the regulation in 1967. Because when I was tasked, or I thought I should take that opportunity to draft language putting that into law, I tried to model it on the EEOC regulation. And in 1967, the EEOC modified what had previously been the regulatory rule. And I thought it would be easiest in terms of getting this law passed by the Senate. It was pretty late in the process, by the way, because, as I said, the House had already passed the amendments to the Civil Rights Act. So I just modeled it on the EEOC regulation. And that seemed to cover that area. And that's the reason it took that form.
Well, that answers that question. And you mentioned litigating the TWA case. And I think it's of more than historical interest. What has been handed down to me is the understanding that the Supreme Court was there quite concerned about a potential Establishment Clause violation, an issue that had not been briefed. Is that correct? Can you speak to that?
Yes, I'll be glad to speak to that. The fact is that this was at a time when, in my mind, the Supreme Court was crazed, really, and I think absolutely wild over the Establishment Clause. They issued at that time several decisions regarding aid to parochial schools in one form or another, which they ultimately overruled. But the Establishment Clause, and particularly after Lemon versus Kurtzman and its infamous three-part test, became something that terrified the court every time there was a religion issue. And in the background of TWA versus Hardison was this fear that, oh my God, and it appears in White's language, really, if what we do is we force the employer to make other employees substitute for a Sabbath observer, we're kind of imposing religion on the other employees. Why should they be harmed in order by the accommodation? Now that, as I say, I view that as kind of a derangement syndrome now. I think the Supreme Court has overcome that fear of the Establishment Clause and gives the First Amendment what I think is a realistic, practical, and correct interpretation. But when at the time that TWA versus Hardison was decided, the court was absolutely, the mere fact that the court could have been equally divided in a case after the 1972 law was enacted on the constitutionality of that law, and that justices like Powell and Rehnquist would seriously entertain the prospect that the 1972 amendment violated the Establishment Clause. That was the issue in Parker Seal versus Cummins. And the court took that seriously enough, with Berger on that side too, to divide 4-4. We don't know exactly who the justices are, but we can speculate. And I think that among the justices who thought that the 1972 amendment was unconstitutional as violating the Establishment Clause were Berger, Rehnquist, Powell, White. I think they're the ones who were concerned about it.
Very, very interesting. Well, I'm happy to hear some of that history as well, because, for me, it's been hearsay. Well, we're going to move on in time because after TWA against Hardison essentially minimized the obligation to accommodate, saying employers only had to do it if it would impose more than a de minimis hardship, really beginning in the 1990s, after the Americans with Disabilities Act was passed and clarified that undue hardship meant significant difficulty or expense. Many of us in the faith community dealing with these issues thought, well, religious accommodation should have the same standard that disability accommodation has. And Richard Fulton, who was legislative director at the American Jewish Committee at the time, led a broad coalition for many years trying to achieve a legislative solution. So Richard, you're up next. Tell us about the efforts to enact the Workplace Religious Freedom Act.
Well, thank you so much. It's really a privilege to be here, and really, especially a privilege to follow Nat. I feel like I'm standing on the shoulder of a giant who, was responsible for those provisions, religious accommodation provisions, becoming part of Title VII, and were the basis for my own modest efforts to try to strengthen those provisions in the light of the unfortunate decision, not only in Hardison, but also other unfortunate court cases in interpreting those provisions of Title VII, which I'll get into. But I want first to note the irony, as a footnote to what Nat was talking about, that the two dissenting justices in the Hardison case, who were very dissatisfied with the interpretation of undue hardship as anything more de minimis, were none other than Justices Brennan and Marshall. So in other words, the liberal lions of the Supreme Court, who one would have expected to be the most sensitive to Establishment Clause problems, were the ones who basically said, that's an absolutely crazy thing, that the court is not interpreting the statute in the fashion that Congress intended, and more than that, there's not an Establishment Clause problem here. Marshall said, an employer, the court concludes, need not grant even the most minor special privilege to religious observers to enable them to follow their faith. As a question of social policy, this result is deeply troubling, for a society that truly values religious pluralism cannot compel adherents of minority religions to make the cruel choice of surrendering their religion or their job. So there you have it. I don't think you can get a better spokesman on your side than Thurgood Marshall, and he spoke very effectively to the to this point. So it was as we move forward in time and we think about what it is that we were responding to, it wasn't only the definition of undue hardship, which put so little burden on employers to show that they ought not to provide an accommodation. It was also the question of what does it mean to provide a reasonable accommodation in the first place. One might expect reasonable accommodation to be one that actually removes the conflict with religious practice, leading to the undue hardship prong, a decision by the courts as to whether providing that accommodation is more than one should expect an employer to do. But instead, you've had cases in which courts have suggested that an accommodation of religion may be considered reasonable even where it forces an employee to compromise religious beliefs or face termination. So in other words, somebody might decide, well, it's a reasonable accommodation if I only make somebody work one Sabbath out of 4. Well, if you're a strict observer of Shabbat, you're going to be out of job in 4 weeks because you're not going to be able to come into work regardless of what somebody, whether it's the employer or the court, thinks is reasonable. Now, there have been courts, to be sure, that have interpreted reasonable accommodation in a fashion more favorable to employees, but that schism in the courts has never really been addressed. And that was one of the things that we had in mind when we started drafting the Workplace Religious Freedom Act in about 1994. The courts have also held, I should say, that employees' rights have sometimes said that it's a reasonable accommodation if an employee is simply subject to collective bargaining agreements or other quote-unquote neutral shift allocation procedures, but that has the same problem, of course. What one does about collective bargaining agreements is another question that if I have time I'll get to, but the fact is, regarding that in of itself as a reasonable accommodation is inherently problematic. So by the late 1980s, these problems posed for employees by the court's reading of 701J, the religious accommodation provisions, had become evident. And behind every denial of accommodation was the story of an American forced to choose between their livelihood and faith, with those who put faith first suffering catastrophic losses, including their homes, their health insurance, their ability to help their children to colleges, even their marriages. I should say, keeping in mind that it's a theme of this year's ABA section to think about issues of economic justice, that the greatest impact of this unfair reading of the law is on blue collar workers. That it's people who are lawyers, white collar workers, not always the case, but often are in situations where they're able to navigate and get the accommodations they need and get a day off if they work Sunday, they don't have to work Saturday, et cetera, et cetera. Blue collar workers, which are, whose work is governed by collective bargaining agreements, whose work is covered by shifts, they're the ones who are hurt. They're the ones that lose their jobs disproportionately. And it's those folks that we need to think about as we think about these issues. So on July 19th, 1989, the late Representative Stephen Solars from New York, Democrat from New York, introduced the Religious Accommodation Amendment of 1989. So that was actually the first religious accommodation bill. But interestingly, the bill did not address the definitional issues of what does it mean to talk about undue hardship and religious accommodation. He rather sought to overturn the Supreme Court's 1986 decision in Ansonia against Philbrook, which was a case that said as long as an employee was being offered a reasonable accommodation, he or she didn't necessarily have to receive the accommodation of their choice. Now, it's nice that he tried to address that, but in fact, the definitional issues are actually far more important. I think most employees, if you had a reasonably defined reasonable accommodation, this issue would sort of take care of itself to a large degree. But that was what Solars did. It didn't go anywhere. He lost his bid for re-election in 1992, and a Solars staffer, who a couple of you may know, David Lackman, transitioned to Jerry Nadler's office. And we were in touch in 1993, together with, and I'm forgetting his name, but it was actually the legislative director for the Seventh-day Adventists at the time. We all got together and started talking about what could be done to fix this problem in terms of how the law applied. And we began to talk the possibility of reintroducing a bill, but this time dealing with the definitional issues. We proceeded to organize a coalition to work with Nadler's office on a new bill, which was initially introduced in 1994, and then in several Congresses thereafter came up through and including the early 1920s. And I just want very briefly to describe what the bill did. Okay, so here it basically defined undue hardship in a fashion consistent with the Americans with Disabilities Act. I mean, now having learned the lesson of what happened to religious accommodation, the drafters, as my understanding, the drafters of the Americans with Disabilities Act included a definition of undue burden as significant expense because they saw what had happened to the religious accommodation provisions of Title VII. So they came up with a better definition, and then we returned the favor by basically adopting that definition into the Workplace Religious Freedom Act. We also put in a provision that said a reasonable accommodation had to actually remove the conflict, also provide the employer has an affirmative and ongoing obligation to reasonably accommodate. On the issue of collective bargaining arrangements, as I'll get to, I hope in a moment, talking about how labor responds to this.
Richard, we just lost your audio. Am I the only one who can't hear him?
I can't hear him either.
Richard, we just lost your audio. Ali, can you try to get a hold of Richard? And I'm going to have to readjust here. So to recap, because as a Seventh-day Adventist, I've been involved with Richard in not only the leadership here of the ABA panel, but in the effort to get the Workplace Religious Freedom Act enacted, going back to 1994. And so the two key issues have been the definition of undue hardship and also what we call the elimination standard, whether an accommodation, in order to be an accommodation, has to be completely effective. And a number of circuits have said yes, but there are circuits that have waffled on that and said no, not exactly. And so that issue of the elimination test and whether an accommodation has to be effective, that has continued to be an issue. The case that is pending in the Supreme Court is Gerald Groff, a Sunday Observer case, Gerald Groff against Louis DeJoy, a post office case. And the Third Circuit in that case said, yes, because the post office did not eliminate the conflict, it did not provide a reasonable accommodation. But on the other hand, it didn't have to because of the de minimis hardship test. So that case is set up very nicely for the Supreme Court, if it chooses to take it, to decide and to revisit the de minimis hardship test and send it back down. And I take some pride in having developed that case at the trial court level, coming out of Amish country, Lancaster, Pennsylvania area. Richard, I don't know if you can hear us, but we are not hearing you. And hence the reason why I've been chatting over you. I'm going to keep going here for a little bit until we get this resolved, because our next panelist was supposed to address these issues from the perspective of a plaintiff's attorney, and that's Menica Fernando. She's with the law firm of Outen and Golden. You don't see her today, a sign that the COVID pandemic has not completely gone away. She's come down sick with COVID. But she has litigated a number of these cases and also worked on legislation with me in California. So I want to make a few points generally from a plaintiff's perspective. First, that Congress has been somewhat ambivalent about protecting the civil rights of workers. So, for example, the 64 statute itself, the amendment to add sex as a protected category was added in an effort to defeat the statute. But also in creating the Equal Employment Opportunity Commission and the obligation to exhaust administrative remedies, et cetera, it was very designed as obstacles to vindicating civil rights, not really as an aid. Looks like Richard is coming back to us. So let's just give him a moment.
Okay, can you hear me now?
You are back, gratefully.
I'm back. I'm really sorry about that. I have no idea what happened.
So I think where we left off, you had clarified, the provisions of WRFA and how it addressed not only undue hardship, but the elimination test, and also was concerned about the impact with collective bargaining.
Okay. Had I talked about essential function?
If you did, we didn't hear it.
Okay. Well, I did talk about it. So the other, I'll forego talking about the other aspects of it, and I except to say that there was no definition or reference to essential function, performing an essential function job in Title VII, unlike the ADA. And so a provision was put in saying that you had to perform the essential function, except that the fact that you're being accommodated has a temporary or tangential impact on your performing the functions should not be deemed to be an inability to perform the essential function. So in other words, the fact that you're not available one day a week because you're observing Shabbat wouldn't preclude you from getting the accommodation. And I should say the bill evolved over time. So everything I'm mentioning was not necessarily in that very first version introduced in 1994. It went on for some time. Now, so in those halcyon days, the bill had bipartisan support, sometimes introduced in the Senate by Democrat John Kerry, other times by Republicans such as Rick Santorum, depending who was in the majority. The idea was somebody in the majority should introduce the bill. The House bill always had bipartisan support as well. And we also had the backing of a broad multi-faith left-right coalition with several bill hearings on the bill in both the Senate and the House. So why didn't it move forward, given that we had this broad support? There were two small problems. One was business and the other one was labor. And the business problems seemed pretty evident. Things are working fine, we don't need it. It's going to require, we're going to have more accommodation requests. They didn't like the way in which we had redefined essential job functions, etc. Whatever it is, we're against it. And on the labor side, interesting, there were never any labor representatives who testified against the bill. What happened was there were some early concerns that were expressed to us, were expressed to congressional officers about how this was going to intersect with that provision I mentioned of 703H, which says that a collective bargaining agreement is, a bona fide collective bargaining agreement should not be deemed to be in violation of Title VII. And we conceded and acknowledged that nothing in the bill purported to override 703H. And in fact, I so stated at testimony on the bill. And so even that was the case, even though we did say in that testimony and said it to labor directly that we were troubled that the collective bargaining representatives didn't seem to see it as part of their responsibility to seek amicable arrangements within the context of an existing seniority system. And in fact, Hardison, I believe, labor actually was on the side of TWA in saying that the accommodation should not be provided. So, and there was some acknowledgement, and I don't know how far this has gone in the interim, but there was some acknowledgement by the AFL-CIO and others that they ought to do a better job of arranging for voluntary shift swaps, modification of work hours, doing other things to work with folks who need the religious accommodation. I'm not up to date on it, but I hope there's been some progress in that over the following years. However, as the first decade, I know that I'm running a little over probably, but let me just conclude by saying as that first decade of the 21st century proceeded, they began to develop a schism in the broad left-right coalition that had supported warfare. And this part of the story is going to sound real familiar to anybody that knows about the history of the successor legislation to the Religious Freedom Restoration Act. Namely, that the concerns were raised in some quarters that RFRA's expansion of free exercise protections of religious accommodation would lead to denial of civil rights in other ways. So that by the time we had a hearing on the bill in 2008 before the House Education Committee, our former ally and support of the ACLU had filed a letter urging that the bill not move forward because, among other things, they said, protect harassment of LGBTQ people in the workplace in the name of religion, that accommodations under WRFA would also be used to limit access to reproductive health care. And to be sure, not all pro-choice or pro-gay rights supporters of WRFA walked away over this issue. I mean, AJC is both a pro-life and pro-gay rights organization, continued to support the bill. I testified at the time that nothing in WRFA's change of definition would alter the fact that courts had consistently recognized workplace harassment as a significant hardship for employers, and also that the courts would find it a significant burden to have to provide an accommodation that had made it impossible for a healthcare provider to provide the care they were in the business of providing, namely reproductive health care, to say nothing of emergency situations. It's not so clear to me that I would be so sanguine about the courts these days, I have to say. But at that time, that was I think a fair and persuasive reading of how the courts had dealt with these kinds of cases in the past. In any event, the bill began to lose its support on the Democratic side. There was an effort to introduce in its bill that would target such non-controversial accommodations as time off, grooming, and dress, affording those practices enhanced protection while leaving other forms of accommodation to the existing standard, to the existing Title VII standard. In fact, in 2012, Senator Kerry introduced just such a targeted bill, but to no avail. And while that approach brought in the left, it was clear that it was losing the right, which felt that it was entitled at least to its day in court and their claims should not be treated under a different standard. Win or lose, that their claims should be regarded in the same way. So suffice it to say then that for the last 10 years, legislative efforts to amend 701J, the religious accommodation provisions, have been dead in the water. That's not to say there haven't been the relevant developments in the courts, and I guess that's what Alan's going to talk about. So thanks very much, and sorry about the interruption with the sound.
Okay, well, it sounds like there has been opposition from both the left and the right, bipartisan support, but also bipartisan opposition, because on the right, Republicans have tended to favor business over religious freedom, which is interesting given the political rhetoric that we hear. So, what are some of the major categories? Where have these cases come down? Probably in terms of sheer numbers, most of the cases have been scheduling related, Sabbath observance, Jewish holiday observance, an occasional Sunday case like the Gerald Groff against Louis DeJoy case that's pending now in with the cert petition pending in the Supreme Court. Second, as you mentioned, with respect to the targeted bill, dress and appearance issues. And if you think about it, they impact, pretty much almost every religion in some way, shape, or form. Some of the leading edge cases there, the Sikh community has a big issue with wearing of turbans and beards. They have been trying to break into law enforcement, and where being able to wear respirator is important. And there are respirators that you can pass a fit test with a beard, but that it continues to be an ongoing issue with both the turban and the beard. Although there are law enforcement agencies that have accepted Sikhs. The beard issue is a big problem for Muslims. Also, I'm sure for Orthodox Jews. Although Nat, I don't know if you want to speak to why it is we're not seeing as many claims brought by Orthodox Jews, it seems, as by others. My suspicion has been that many are working in areas and in industries that are more receptive to the community, but I don't know that for a fact.
Well, I'm ready to speak to that very briefly. I can tell you that I personally have litigated beard cases, one in the New York City Police Department for official litzman, and won that in the district court for the Southern District of New York. The New York City Police Department claimed that police officers had to wear gas masks and they wouldn't go over beards. We disproved that. The district judge, whose name I now forget, ruled for us. And Litzman is now a very respected member of the New York police force. With regard to beards in the United States, I represented a chaplain by the name of Stern, who we litigated in the district court for the District of Columbia and prevailed on the right to wear a beard in the U.S. Army. The military has been very reluctant to accommodate to beards, and yet they have lost beard cases against Orthodox Jews. So I have to dispute your proposition that Orthodox Jews have not litigated that. They have. Maybe I have been delinquent in not getting enough publicity for these cases, but we have litigated them and we have won them.
Well, amen to that. As Richard suggested, on the right, there are a certain number of claims. For example, nurses and doctors objecting to participating in providing abortion services or other medical procedures. There have been cases involving a refusal to participate in providing in vitro fertilization for same-sex married couples. A prominent California case. More recently, we are starting to see cases where there are objections to the use of pronouns, where employers may be requiring or really discriminating against people who think that they can be respectful to transgender people in the workplace without having to use pronouns. I think we're going to see more conflicts like that. Probably the most common claim right now inundating the EEOC and some of the state civil rights agencies are religious objections to the COVID vaccine. And while some employers have been quite generous in providing accommodations, there's also been quite a bit of hostility. And I think one of the interesting aspects of these cases is that I think they're going to put a lot more emphasis on the issue of sincerity of religious belief. That has not generally been a key problem. If somebody loses their job because they won't work on a Sabbath or for some other reason, it's a pretty good indication that they have a sincere religious belief. Although if they have been inconsistent in the past, there might be a tribal issue of fact that the judge is willing to go to the jury if it gets that far. But the COVID cases, a lot of the employers have been trying to screen people out to determine whether their objection really is based on religion or something else. And I think some of the means that they've been relying on to do that have been flawed. And I think the COVID cases are going to give rise more and more to related claims of religious discrimination, not just accommodation claims, but retaliation and harassment claims. Because in the law, if you tell somebody either get vaccinated or you're fired, that's a kind of quid pro quo. That's an illegal choice between your religion and your job, and it's much more direct in these cases even than in cases like beards or Muslim women wearing headscarves or Sabbath observance. So I think that's kind of the roundup of the types of cases that we've been seeing. So I'm going to move on then to our next panelist. Richard had mentioned that the conflict, or at least potential conflict, between religious accommodation claims and other civil rights concerns certainly had a negative impact on the progress of WRFA. Jenny Pizer, our next guest, serves as Chief Legal Officer of Lambda Legal, the oldest and largest legal organization working to achieve full civil rights for LGBTQ people and people living with HIV in the United States. And Jenny, reading, some of the materials from Lambda, your amicus brief in the Abercrombie case, it strikes me that you guys are in a unique position of both seeking protection for religious accommodation, but also for civil rights. Talk to us about that perspective and where you see common ground and where you see either actual or potential conflict.
Yes, well, first of all, I want to say it's really a pleasure and fascinating to be part of this conversation. And I do think that we're dealing here with some of the central issues of our American society and how we understand core constitutional values. So it's endlessly fascinating, and I'm delighted to address this. And I guess I do want to start with a perspective that, yes, Lambda Legal absolutely affirms religious liberty as a core constitutional value, very important. And that's a programmatic value at Lambda Legal. It's also a personal value for many of the lawyers and other staff of Lambda Legal. As it happens, our director of constitutional law practice is married to a rabbi. And there's a reality, I think, and sometimes a perception that is challenging in the popular media and sometimes the popular perception that we have conflict here. Sometimes the phrase that I hear is sort of gays against God or God against gays as this sort of polarizing fight. People don't recognize what I think is the reality that in the United States today, an enormous number of LGBTQ people are people of faith. who participate in the breadth of denominations and traditions, and an enormous number of congregations are welcoming. And those that aren't often have a separate group that recognizes that tradition, but creates a welcoming congregation. If you think about the range of faith traditions. And I start with that principle because I think that the way that is perceived and sometimes amplified in the media, because, you know, nothing makes a better headline than a good fight, that it does tend to encourage overlooking of the common ground and the ways that we as lawyers can have a role to play to seeing where there's actually a lot less conflict than may appear to be the case. So I do start with that, and you mentioned our brief to the Supreme Court in the Abercrombie and Fitch case, which was about the duty of the employer in that instance to do a proper inquiry about whether there really was a conflict or a way to accommodate an employee for a job. The issue was a head covering, and that the employer didn't perceive that there would be a problem and engaged in no communication with the applicant. The applicant didn't realize at the time that she was being denied a job based on assumptions about her and what her religious needs might be without any conversation. And so that is, I think, one example of many where we should understand what undue burden is. And I would say we don't necessarily disagree with some of the folks looking to have the Supreme Court adjust that standard and require a bit more. I think part of our perspective, there are maybe two big principles that I would flag, and I want to say a little bit about how I think that plays out. But one is that we can recognize that society as a whole has written rules to accommodate, in broad brush terms, the religious needs of the majority, and that minority faith groups don't have their needs met the same way because they're a minority. And so to recognize equality and inclusion, there should be accommodations to recognize that it's not that everything is secular, it's that some people are having their religious needs met and others are not because they're a minority group. So I would give that as one guiding principle. Another guiding principle, though, that is immensely important to the LGBTQ community is that religious accommodations must not be at other people's expense. And when I say expense, I don't mean the minimal burdens that we manage about scheduling issues when they are really not the sort of burden beyond which we bear in the workplace. We have to do a range of things to work together. But when the burdens that would be imposed are harassment, are exclusion, are mistreatment of various kinds that come not from these are my needs about me, but are about disapproval of you. And granted, there are circumstances when distinguishing between those two types of things can be complicated, but it is a basic principle. So in our work, we deal with a reality, I think a perception and a reality that it is a newer concept that LGBTQ people, like, we're okay. We're not actually a problem. We want the same freedom other people have to have legal protection and to live our lives and to be ourselves. For those who are believers, it might be phrased to live as God made us. And for, again, people who are believers, you know, God doesn't make mistakes. We are who we are. We're fine. We've always been here. What we ask is to be recognized for who we are and to live full lives and contribute in full ways against a history of really horrifying abuse and beliefs that may be protected as religious beliefs, but are contrary to what society, what we have come to understand through social science and medical science and et cetera. And we address this in a context of incomplete legal protections at this point. Here we are in 2022. we have some legal protections. We have some protections quite good in some states, zero in other states, a time of overt political activity to deny us inclusion and legal rights. And at our legal help desk, which is staffed by lawyers, we get thousands and thousands of calls every year for legal information and help. And workplace problems continue to be the overwhelmingly large category of problems. Used to be sort of evenly split family law problems and workplace problems, and with equal marriage rights at this point, the workplace problems now dominate. And that's because of people interacting with each other from different backgrounds and different belief systems, and there being a social dominance and an ongoing belief, I think, that religious reasons for discriminating or religious, whether the word condemnation is strong, but anyway, disapproval, let's say, of LGBT people deserves more accommodation and respect. It's more understandable, it's more reasonable than religious beliefs for white supremacy, for example, or for excluding women from various parts of public life. And I think that some of that is just advocacy in the passage of time, and that beliefs change through conversation. But I do see that as where we are right now. And that's a pretty serious problem that at Lambda Legal we're trying to get the understanding aligned so that there's room for everybody in a respectful way. So to quote some of the Supreme Court cases, freedom to believe is absolute, but freedom to act on those beliefs cannot be, if we're going to live together in a diverse society.
So I saw Annette had your hand up. Go ahead.
Well, let me say I agree entirely with Jenny's very moderate and sensible view that we have to live together. But a Supreme Court case that was before the Supreme Court case and may come up very shortly points up how aggressive LGBTQ might be, not to try to live together, but to aggressively demand that it reject religious rights. The Yeshiva University case. I'm a graduate of Yeshiva University. I respect its rabbis. I respect its legal tradition. And they have decided and repeatedly said that they welcome LGBTQ students and will be very, very hospitable to all LGBTQ students, but will not formally recognize an LGBTQ club, the Pride Alliance Club, as a formal Yeshiva University undergraduate club. Now that is trying to live hospitably and harmoniously with the LGBTQ community. And nonetheless, Pride Alliance chose to initiate an action under New York law in which Yeshiva University was condemned and ordered without even a stay to recognize an LGBTQ club. That's not the harmony that you've spoken of. That's aggression against religion.
Well,
So, Jenny, if I may, because this actually takes us afield from Title VII, and there clearly are existing conflicts, as you've highlighted, Nat, and that is a significant pending case. I believe the Supreme Court declined to take up the case in the first instance. I do want to get us refocused, but Jenny, go ahead and speak to that briefly.
Super quickly. And yes, and we're here basically to talk about Title VII, but there are issues where this overlaps. And so the main thing I would say is, I think as a society, we have a challenge right now because there have been some changes in expectations about public funding of institutions. And I'm not going to claim to know all the relevant facts about the yeshiva case right now. So I'm not going to argue the details of that one. But speaking more broadly, I think that there was a move a couple decades ago to make it much easier for faith-based institutions to receive public funding, the Charitable Choice Act and the Faith-Based Initiative. And so that has taken us to a time of a lot more public money going into faith-based institutions. And I think social service and medical agencies are different from educational institutions in important ways. But there is a big question about whether how we deal with public funding of institutions that want to provide services and have employment according to religious rules, when institutions, and I'm not saying yeshiva is one of them, but play an important kind of public function. Social service agencies and medical institutions in particular. Because
so Jenny, I'm going to cut you off and get back on track. That is an excellent topic for a subsequent ABA panel, and Richard Fulton is our chair, and Rama, who introduced us, is I think either a co-chair or something like that, and myself. So point well taken. Go ahead, Nat.
I just want to address one point of information regarding what you said, Alan, that the Supreme Court may have denied certiorari, but there were at least 5 justices who said to the New York courts, if you don't grant a stay, we will grant a stay. And as a result of that, I mean, what has not received publicity is the result of that Supreme Court opinion, which was issued by the court as an order. The Pride Alliance said, okay, we'll accept the stay in the meantime. That was accepting under duress, I have to tell you. The reason they accepted is because the Supreme Court said, if you don't, to the New York courts, if you don't do it, we'll do it. And therefore Pride Alliance said, okay, it's a stay. But nonetheless, is only addressing Jenny's very reasoned and sensible approach that there ought to be harmony and reasonable cooperation between the religious groups and the LGBTQ groups.
So I want to make a couple of observations going back to Jenny's point. First is the issue of impact on third parties is an ongoing subject of litigation. The statute itself says that the hardship must be on the conduct of the employer's business. And so those of us on plaintiff's side, companies will argue, well, if I have to, accommodate a schedule, that's going to have an impact on those who have to cover that shift. And that impact on third parties is sufficient evidence of undue hardship. So this is an ongoing concern. I appreciate, Jenny, your point of view, which distinguishes between issues like harassment, which really third party coworkers should not have to be subject to, and changes in schedule and other kinds of burdens that should not be seen as rising to an undue burden. But I also just want to reflect that what I'm also hearing, I think, is a recognition that as Professor Alan Brownstein and I have written and argued together in various places under the title "No Right is an Island," that all of our civil rights kind of stand or fall together in some ways, and that the Bostock decision recognizing sexual orientation as covered under Title VII, is in some part the legacy of decades of support from the courts for civil rights, and that if the court does take up the Gerald Groff against DeJoy case and give us a good ruling on reversing Hardison, that too is in part the legacy of Bostock and the legacy of Obergefell, and a whole line of cases that develop the respect for civil rights. I'm wondering if you want to speak to that for a moment.
Is that addressed to me?
Yeah,
Yeah.
kind of the notion that our rights really, you can't just separate them and say, oh, we have rights in conflict. Those are the cases that the media likes to focus on, is when rights are in conflict, when a Christian baker doesn't want to bake a cake, for example, for a same-sex couple, and you have rights in conflict. But the fact that rights really build on one another, and that we have more in common. I just wanted to get your perspective on that, Jenny.
Yeah, well, absolutely. Well, I think we have had, and this is actually the bit of a subject of the double issue of Human Rights Magazine that Richard and I worked on together, which was published by the Civil Rights and Social Justice section. It's available on the website. I commend it to people. Essays from different perspectives addressing where are there tensions and how might we deal with the tensions. I think we've had a framework in place for quite a few years. And I realize this panel is a bit about whether this particular protection for religious accommodation has not been working so well. So I'm not going to say that the framework is perfect. But in many ways, we've delineated some spheres of public life that are subject to regulation. Employment, public accommodations, housing, especially when there's public money. And I think we've generally said that these spheres need to be open to everyone. And that there are other spheres where people don't have an expectation, shouldn't have an expectation of being able to enter. And, there where people get to do things according to their own rules, as long as there's, not danger to people, physical danger or danger to children or what have you. So if you look at cases like, and some of these are public accommodations cases, but they can be employment matters as well, where, as the Supreme Court said in Masterpiece Cake Shop, for example, well, generally speaking, religious objections to your customers does not give you an exemption from a civil rights law. You need to serve your customers. And the way I've understood this is, when you're operating a business, you decide what your endeavor is going to be. You decide what goods or services you're going to offer. And then, having made that decision, you need to sell them to members of the public consistently with civil rights laws. And we have not embraced the idea, or at least the law used to be, I should say, that a person or a business owner's view that other people's conduct is religiously improper, that you may believe that you become complicit in that bad conduct if you serve them, or if you hire them, or you engage with them. But the law isn't going to work that way, because they're making their independent decisions and you're living your life and you're having an interaction in the public arena. So it's been very worrisome from our perspective to see the Supreme Court, for example, in the Hobby Lobby case, accept the idea that the business owner who had a belief that having contraception within their health plan created a religious burden, that should be accommodated because the employees who needed contraception could get it some other way. And we saw that same idea in the Fulton case. Well, Philadelphia is contracting to provide care for kids, placement for kids, screening potential families. And in Philadelphia, there's lots of agencies, so same-sex couples can go elsewhere. And so this is a comment about tension between rights, but when we're seeing it in the public accommodation space, bringing it into the workplace context, there have been a number of cases, and we were talking about them before the webinar began, where employers want to have a more harmonious, inclusive workplace, and so they have diversity training. And some employees object to the diversity training on religious grounds, and there's been litigation about that. Or there's been an employee who wants to express their religious views that are condemning of people in a same-sex relationship. That's been more of the cases, but it could be the same reasoning for somebody who identifies as transgender. And the employer saying, well, this is creating a hostile environment for your coworkers. You can't post those things in your workspace, or you can't engage your fellow workers in about your religion that says there's something wrong with them. And how do we have, so there are conflicts about this. How much expression of what amounts to harassment? I mean, this is a problem for people who work in employment relations going back quite a long time, whether it's sexualized comments or comments about ethnicity or race, or here, religious beliefs about other people. How much of what kind of comment should be considered actionable harassment? Does it have to meet a legal standard of actionable harassment for an employer to say, you know what, that's not helpful. No more of that conversation. You're upsetting people. Maybe it's not enough to give you a federal claim, but it's creating dissension in the workplace. And we've seen, for example, in the non-discrimination law that was passed in Utah a few years ago, some language added to the bill that became law requiring sort of equal treatment or equal time for religious speech as for other kinds of speech in the workplace. And I think for all of this, it does take me back to this first principle of whether people are engaging in ways that are putting somebody else down. And that can, I mean, that is something that we all have an equal stake in, because I have come to understand there are certainly people, and we see this in some of what Justice Thomas and Alito have said in some of their concurring opinions, a concern that religious believers, especially people with more conservative beliefs, are being pushed out and are being silenced or canceled, to use the language that is common now. So really, this rule of people being respectful of each other, and I'm talking here about Title VII governed contexts, that protects everybody. And that actually was one of the themes that we addressed in our amicus brief to the Supreme Court in the Kennedy versus Bremerton case. The decision did not go the way we hoped it would, but we were writing about the fact that social trends or controversies change over time, and that a group that may be dominant at a particular moment, including a religious group that may be dominant at a particular moment, may be the minority tomorrow. Really, if the Establishment Clause is going to continue to become more and more ephemeral, which is how we're seeing it, I think that people of many different types of faith are going to feel less and less comfortable in more and more workplaces, as some religions are given a lot more deference.
Well, your comments, Jenny, take me back to kind of the basic principles of why we have Title VII in the first place. And that, prior to 1964, it was perfectly acceptable for, as Nat, as you introduced it, for law firms in New York City to say, we're not going to hire Jews. So the idea of a more inclusive workplace is really at the heart of what this is about. Richard?
Yeah, so I wanted to just make a couple of points that these last couple of exchanges have brought to mind. One is just the observation about the colloquy between Nat and Jenny that started us off, that there are still a lot of these unresolved issues, and they come into play most of all, I think, not in the context of businesses that rightly ought to be expected to not be able to apply their particular religious beliefs, impose their religious beliefs on others, but in the context of the intersection with religious institutions whether or not they receive public funds. And, I'm thinking here about the Equality Act, which is wonderful. If it's ever enacted, it will be a wonderful incorporation of sexual orientation and gender identity into the protected categories in a range of titles of the Civil Rights Act. But it does raise the question as to whether sufficient room is being given, and here there's not even a requirement of public funding, whether sufficient room is being given to religious institutions to act in accordance with their faith and not have not have the state impose itself on those determinations. I'm thinking about Hassan Tabar, which was a Title VII case, where the court said we're going to, certainly when it comes to the hiring of ministers, that's none of the state's business, good or bad, and we just have to stay out of it because this is a different space. This is their space, and I think Jenny, you said something about that. I think something's being their space. So the question is, the difficult question is, where do you draw the line? At what point is it a space that has to be respected, whether or not we think somebody's doing the right thing, versus a space that even if we intensely dislike what they're doing, we have to say, if we're going to have freedom of religion in this country, there have to be things that religious institutions can do in ways in which they can behave and separate themselves that are not going to be imposed upon by the state. So that's one issue. The other thing that really came to my mind is, much as I like the idea, Alan, of saying that our rights all build upon one another, and to some extent that's certainly true, there are going to be conflicts. There's no question that there's going to be conflicts. These are difficult issues having to do with contention of important interests, constitutional interests that we have as Americans, our commitment to religious freedom and our commitment to non-discrimination. And they will come into conflict. They're not easy answers to them. I guess and as John DiIulio once said, we know things are important in the United States, we go to court when they're important. And so these are cases in which people are going to go to court because they were dealing with issues that are very important to folks that are on both sides of these issues.
So let me get to some of the questions that have been raised. First, really more looks like a comment that somebody said, it looks like this track is against religious freedom of others, whether public or private. And I certainly hope that's not true. I think all of us in our own way are advocates for religious freedom. A specific question has been, and I don't know if any of you can answer this, what cases have been decided by the U.S. Courts of Appeal, if any, on the question of sincerity of religious belief? Is Ballard in jeopardy? I've had a couple of summary judgment rulings, at the trial court level, but I'm not aware of appellate rulings. Nat or Richard, are you?
I can't say.
I'm not. And again, in the cases that I've litigated, the plaintiffs are the ones making the religious claim are so obviously committed, in terms of my clients, committed to Jewish observance, that nobody has really challenged that. They've challenged practice. You, I think, had suggested the original yarmulke case, skullcap case, that I did take to the Supreme Court and lost in the Supreme Court in a decision that I think constitutional professors roundly disparage today, Goldman versus Weinberger. And in Goldman versus Weinberger, I was very surprised to see the Solicitor General's representative argue that, well, there's a disagreement within the Orthodox Jewish community whether wearing a skull cap is really obligatory or not. There wasn't any question the client whom I represented was wearing a skull cap, a yarmulke, at all times. So whether there was a disagreement within Orthodox Jewish law about wearing a skull cap at all times was really not, I think, an issue in the case.
Well, I think it was uniquely inappropriate for the government to try to argue, somebody's religion that way. I think I saw hands from both Richard and Jenny. Go ahead, Jenny.
Well, what I was going to say is not exactly on that point as much as to use a piece of California law as an example of how to approach some of these things. And I think, Alan, maybe you mentioned that you might have even had some involvement in the passage of this law, so it's part of our employment non-discrimination law in California that was enacted in particular to provide greater protection to members of the Sikh community. And it calls out religious grooming practice, hairstyles, clothing, head covering, beards, and so forth, as it being an important part of religious observance that requires accommodation, gives a higher standard of the employer's duty to accommodate. And it has a couple of specific elements that I think give a good picture of where this could go. These days it's hard for things to get through Congress at all, as we all know. But there are elements to this that I think are a good model, because with that bill and the amendment to California law, there were elements to define what makes up undue hardship. It includes specifically that people can't be segregated from the regular workforce as part of their the accommodation, and an accommodation of an individual's religious dress practice or religious grooming practice is not reasonable if it requires segregation, or if it involves violating the civil rights of others. And in California, the law against harassment applies if an employer has only one employee, as opposed to the general non-discrimination law that applies if there are more than one employee. So there's greater protection against harassment, greater protection of the civil rights of third parties, and explicit protection for religious needs that are very important, frequently not taken seriously enough, and that generally speaking don't affect other people. One of the things I would call to our attention here is when there's argument about an employer's need to, quote, remove the conflict, and a mention of religious practice, all elements of religious practice, I would just point out that it depends what the religious practice is, as I come back to the idea that when a religious practice would be at the expense of some people, like, for example, a religious view long held that women and men must not work together in the same space, must not be together in the same space. If the removing the conflict would mean making the women leave, like the case in New York, the name of which escapes me, but the Hasidic male students that couldn't be on a bus driven by a female bus driver, well, you couldn't accommodate that religious need by violating the Title VII rights of women who could drive buses. So I think we have to be mindful that the language we use is sometimes overbroad because religious needs and religious practices are so diverse. So we can't necessarily, if remove the conflict means do whatever the religious need may be, that can be impractical when it falls on third parties. But doing an interrogation of what is the religious need, and can we have a respirator or a mask or something that can accommodate a beard, or head covering that can accommodate a turban, like, look at what the facts are. Come on, make a decent effort so that people can have the full range of employment opportunities.
Well, let me kind of update on this sincerity of belief. Go ahead, Richard. Go ahead.
I just wanted to make very quickly, something can be reasonable accommodation, just referring to Jenny's point, but still be pose an undue hardship for the employer. And I think that, again, having somebody want as their religious accommodation that they not have to work with a woman may accommodate their religious belief, but it's an undue hardship to the employer to put them in a position where they're violating civil rights laws. So I think you can get to the same place and still have a kind of broad definition of religious accommodation, given the breadth and variety of religious practices, and not wanting to narrow that too much. Also, just on the question was raised earlier about sincerity. I think one of the problems we have with the COVID cases is there's so much widespread evidence and belief that many of these claims are in fact not sincerely placed, that you've had folks arguing, in effect, we do have to interrogate them not only on what they need, but on the sincerity of this, because you've got so many cases where folks they're getting boilerplate letters from their clergy. There's no evidence in their past conduct that they ever had any religious objection to vaccinations. I mean, to be sure, there are people with sincere objections, partly pro-choice folks who say the drugs are derived from fetal tissue. So, may not agree with the reasoning, but it's sincere on their part. But there are others who are raising these objections, who any investigation would show are really raising a political perspective, and perhaps just, it's got nothing to do with religious accommodation. But that makes that's bad for everyone that seeks religious accommodation. When you have one situation where a lot of folks are acting on a basis that causes you to reasonably doubt their sincerity, that's going to cast a pall over getting religious accommodations in cases where the sincerity ought not to be questioned. And that as many of these hard cases do, it puts us in very, very tough.
Well, the ultimate illustration of all that is the difficulty that the federal courts had with the Church of the New Song, which was a church that was created in federal prisons. I think it was in the Fifth Circuit, maybe Atlanta, in that the church claimed that the inmates in the prison claimed they were members of the Church of the New Song, and therefore they were entitled to steak and sherry every day, one meal each day of steak and sherry. And frankly, it bedeviled the district judges who had to deal with that problem until they finally did hold a hearing in which they determined that this was a totally false religious claim. So that's what you end up when you have this, this resulted from the fact that kosher food and food that was satisfactory to Muslim inmates was provided in the federal prisons. And the Church of the New Song decided they would take advantage of that.
Let me, you got my brain spinning here on various sincerity issues. Nat, you remind me, my favorite case to talk about this has to do with the Church of Body Modification in, let's see, that was the Cloutier against Red Robin case. And the court there, it was a very new religion, person wearing facial piercings that the employer did not accommodate and fired. The court did not rule against the plaintiff on the basis of lack of sincerity, but one has to wonder whether that was not really the ultimate cause of the court ruling against the individual and in favor of the employer. I had two back-to-back summary judgment decisions in federal court in cases that have since favorably settled, involving Sabbath observance, where both individuals had on occasion worked on Sabbath. In one where it was only maybe once or twice the evidence showed, and when she was part-time and struggling to make any money at all, the court said that the law does not require perfection. That, of course, is language that we love to cite. And then another district court in Arizona considered our summary judgment filing on behalf of a truck driver who had, over a course of about 3.5 years, when things were very slow during the summer, accepted driving on shifts that conflicted with his Sabbath 13 times. And there the court was willing to let that go to a jury on the issue of sincerity of belief. That case also favorably settled. So there is some conflicting. I think with the COVID, back to what Richard was saying in the COVID area, we're seeing a number of problems for employers firing people who are working remotely, And also one major employer who I won't name by name that was screening thousands was doing them all on the basis of questionnaires. Now, our office has screened hundreds of these claims, and our staff, several of whom are not lawyers, are very quickly able to distinguish between those who have genuine religious objections and those whose objections are otherwise. But they do that on the phone in polite conversation as such, not on paper. And I think that's a big problem. How do you determine sincerity of belief? The fact is, just because somebody submits these form letters, which we've been counseling people not to do, it may be that they're scrambling for support for a belief that is otherwise sincere, or it may be that, yes, it's a fig leaf to cover other kinds of objections. So I will say, so far, the courts have generally been pretty sympathetic and favorable to the COVID objectors. We'll see how that continues to develop. Let's see. Looking for other questions. Did you want to comment, Jenny?
Well, could I raise?
I just wanted to say, as I know we're coming to the end of time, that to the question of what do we think is possible moving forward, I would just suggest that an example of the California law I described, or the federal Religious Land Use and Institutionalized Persons Act, are examples of more targeted demonstration of there being unjustifiable burdens on religious practice that can be addressed, that for some of us who deal with such widespread discrimination by many people who I think sincerely believe, if we talk about sincerity, that religious beliefs are a reason to discriminate, that if one acts based on religion, one is acting like a good person, and that therefore whatever they may be doing isn't discrimination. It makes us quite nervous when we see something like the Religious Freedom Restoration Act as passed in '93 with a congressional record that said, and I quote, "Nothing in this bill shall be construed as affecting Title VII of the Civil Rights Act of 1964. And then we see in the Supreme Court's Bostock case, Justice Gorsuch's opinion saying, hey, I'm not addressing RFRA, and by the way, RFRA is a super statute. It makes us worried that original language that seems to respect third-party interests doesn't necessarily have the traction moving forward in time, especially in the current Supreme Court, which the track record of which seems to consistently be favoring the religious claimants, including in the COVID cases, but not just the COVID cases. So when we look at why there has been more bipartisan support for religious liberty protections in past years, I suggest to some of you that this may be why.
Richard, and then I'm going to ask Nat a closing question.
Yeah. Okay. Actually, I have a question for you, Alan, if I might quickly. Okay. But I just want to say, this goes to the point, Jenny, what you just said that I made earlier, that I'm not sure I could deliver the same testimony today that I did in 2008 about how the courts would not read the religious accommodation amendment that we were suggesting in a way that would lead to harassment in workplaces. I wish I could still say that I had that same confidence in the courts, but things have changed, to quote Bob Dylan. So the question I had for you, and really I know we're running out of time, but I'd like a concluding topic. We haven't talked overly much about Abercrombie and Fitch, and you, of course, are litigating cases seeking to have Hardison revisited now in the courts, and there was an interesting point made in a brief, if not on that case, in another case, which basically said, in light of Abercrombie and Fitch, which says that Title VII requires disparate treatment, that favorable treatment on the basis of religion, it requires disparate treatment analysis, in effect saying that it's giving greater weight to Title VII's religious comments beyond the holding of that case, which is about at what point a complaint attaches. There's substantive language in there, maybe it's dicta, but that provides for a much stronger and more robust interpretation of the religious accommodation provisions, Title VII. So one argument that has been made is, in light of that, the reasoning behind Hardison, that there was some kind of constitutional problem that we had to be careful of, really falls by the wayside. Hardison makes no more sense any longer, given what the court said in Abercrombie and Fitch. And I just wanted to throw that open to you, Alan, as
Well,
what you think of that argument.
I think it's certainly true. And, the language of Abercrombie that says that those seeking accommodation are entitled to favored treatment is the clause. We cite that in all of our briefs, even in complaints sometimes. So, yeah, we lean heavily on it. At least one scholar friend of mine thinks that Abercrombie should have changed kind of order of proof in the prima facie case, but the courts seem to be stuck with the traditional analysis. It certainly, Abercrombie did recognize that religious accommodation is not a standalone, that it is a species of disparate treatment. But I wanted to give Nat the last word. 50 years later, here we are. Have things worked out the way you hoped? To what extent, yes. To what extent, no?
No, of course, they have not really worked out totally, at least hoping that TWA and Hardison gets overruled. But the main objection right now is what my classmate Nino Scalia very surprisingly did in Argonne versus Smith. That is really the worst decision with regard to religion that has to be overruled. And, why Scalia did that, very interesting possible theories one could have regarding that decision. But I think even very shortly before his death, he began regretting having issued that decision. And how someone who has committed a religionist, as Nino Scalia was, could have written Argonne versus Smith and thereby turned the free exercise clause into simply an anti-discrimination provision, that gives no rights really to free exercise of religion and hampers religious exercise to this day. I mean, Justice Alito's, I think, brilliant separate opinion in Fulton, which I think was written originally in the hope that it would be a majority opinion, ought to be what the Supreme Court focuses on. So after 50 years, do I think that the court, the country is where it should be on freedom of religion? Absolutely not. Do I think there's a possibility that with this court, there might be corrective action within the next couple of years? I'm hopeful.
Well, thank you for joining us for this free webinar. We'd like to express our gratitude to this esteemed group of panelists. You are all doing such critical work, and we thank you for taking the time out of your schedule to share your experiences. The section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming active in the ABA. You may do so at ambar.org/CRSJ. Best of luck in your work and stay safe, everyone. Goodbye.